a petition, but I did not get the stay, that's why it's highly obliged.
My lord, I'm waiting on matter to be listed on 8th of December, my lord. It was last listed on 13/9/2024, my lord. Returnable date is already over, my lord.
Production is not finding.
8th of
Not
December,
possible on 8, some other day, 11.
my lord. Apply.
Yes, Mr. Doctor, I beg to mention for urgent listing of an AB, Lordship, the matter is of urgency as the petitioner is being actively searched by the police. Let the matter come tomorrow.
How many years punishment? Not tomorrow. How many years
7
punishment?
years.
Huh?
7 years, more than 7 years.
Huh?
More than 7 years, sir.
More than 7 years. কেতিয়া দিব পৰিছাকখন? 10 December.
Yes.
May I please, your lordship, I pray for listing of a criminal appeal any date before vacation, my lord.
16 December.
Can it be 17th?
No, please, your lordship, listing of a criminal petition, your lordship, last listed on 14 May, your lordship. On Monday or Tuesday, your lordship.
16 December.
16 will be different. Tuesday, not 9th, your lordship. 9th, 9th.
May I please, your lordship, I beg to mention criminal petition, my lord, to come up for hearing, admission hearing, my lord, on 11th December, my lord.
16th.
And another criminal appeal, my lord, my lord, to come up on 11th of 16th.
16.
What are 16th? No, sorry.
May I please, your lordship, I beg to mention for listing criminal petition for orders. Lordship may be come up on 9th of December, 15th December.
I want to submit a mention memo if the cases are today in the afternoon.
Not in the afternoon. Tomorrow morning.
Meaning person.
You want to
Then
submit
it-
mention memo.
Then
It-
8
In the
8
after-
December.
You want to submit, then you can submit by, after.
8 December.
Huh? On 8.
8 December.
Yes.
May I please, your lordship, I beg to mention one IA for orders column on 11th of this month, 11th of December. The matter is very,
Bail.
no, my lord, for consider the interim compensation. NI Act matter.
Total hearing of serious. Yes.
Oblige.
I am praying for a listing of a regular bail exemption tomorrow, lordship. I have filed it already, lordship. Tomorrow for motion, lordship.
Kalia. No, not possible.
On 8 December.
Another lordship, criminal petition, lordship, may can be fixed for orders, lordship. On lordship, 17. 15. 15. Oblige.
My lord, I beg to mention for listing on AV. By tomorrow may be taken up, my lord.
8 December.
Oblige.
Lordship, item number 14, the leading counsel is out of station. Leading counsel is out of station, yes, sir. So kindly list the matter after vacation.
Lordship, I am the respondent, lordship. I have objection, lordship. Please the matter.
What is your name?
N Islam,
And
N Islam,
Islam, Learned Counsel Mr. N Islam on behalf of the,
A Islam,
on behalf of Learned Counsel Mr.
A Islam.
A Islam has prayed for adjournment as Mr. A Islam is, as Mr. MD A Islam is out of station. Learned Counsel Mr.
AK Das, respondent number 2.
AK Das, for respondent number 2 has raised objection. List this matter, when do you
Take-
want?
Lordship. No, before vacation, lordship.
Uh,
Any date, lordship.
List this matter after 1 week.
Lordship, date may be given, lordship.
He'll be
Hearing-
back, no?
On 18 December.
He'll be back on 18 December.
No problem.
Huh? He'll be back.
Obviously.
Yeah, please, your lordship. I beg to mention item number 11, lordship. Password for the day. I should do some difficult.
Request has been made to pass over.
Fixed for 10 December, lordship.
This matter on 10 December.
Okay.
10 December, fine. No, like it, very basic.
The motion matter, lordship.
12 December.
12.
My lord, please, yes. My lord, I am a social activist, my lord. My lord, I have raised an objection with regard to the distribution of Prime Minister Ujjwala Yojana gas cylinders, my lord. And for that, my lord, I had raised for few economically weaker section. What in contrast, what this the owners have done, they have filed a long extortion case and other cases against me and the supply inspector itself. I am apprehending arrest, my lord. My lord, if this matter is an AB matter, my lord, if that can be taken up in the earliest convenience of this honorable court, my lord.
That is registered under which sections?
My lord,
Is it more than 7 years punishment?
yes, my, it involves 7 years and actually what does happen?
Cylinder per special act habo na?
My lord, you see, ECC,
Yeah.
because I
Did
am,
your-
my lord, my lord, on
December.
7th of December, my lord, if. My lord, on Monday, my lord. Deeply obliged, my lord.
May I back to mention item 23, Lordship. Kindly pass out the matter for the day, Lordship. Next week,
my lord, CD receipt, my lord.
next
Send
week, any
the
day.
CD, huh?
Next week, any day, Lordship.
Next week, then we can retain
Monday.
till next week.
Monday.
Learned Counsel, Mr.
SK Chhetri.
Chhetri has prayed for adjournment. CD is received. Retain the CD till 11 December and list the matter on 11 December.
Wait, please, my lord, I'm mentioning this matter for listing, my lord, a BA, regular BA, my lord. This under very compelling circumstances that I am mentioning before this honorable court. My lord, what has happened, I was facing the trial in a special,
What,
Yes,
under
ma'am.
which sections?
my lord, POXO matter.
POSCO.
Oh, yeah.
See, as it is, you'll have to issue notice, so we can list it on any other date.
My lord, what has happened, my lord?
Tomorrow, you
Okay.
want it tomorrow?
Yes, my lord. What has happened, my lord? An NBW, I was facing the trial, my lord.
Okay, we'll, see, tomorrow you don't press for bail, we'll have to issue notice.
My lord,
POSCO matter.
my lord, the matter is that an NBW was issued against me. I was facing the trial, my lord. I came before this honorable court, my lord. I was granted the liberty to approach the honorable trial court.
Belagata didn't did you?
9th December.
9 December.
Tomorrow, my lord,
No.
if it's not inconvenient.
The way you're submitting, we'll have to hear you on 9 December. Tomorrow we cannot accommodate you.
My lord, it is, my lord, liberty was granted, my lord. The trial court has stated
This is AB or BA?
BA, my lord. Trial
9
court is,
December.
my
9
lord,
December, 9 December.
if it can be tomorrow, my lord.
No. If you accept that notice, maybe you should only one order is passed, maybe passed, then I can fix it up tomorrow. But if
Then, my
you,
lord, tomorrow, my lord.
but you cannot submit for stay.
My lord,
Then 9th, I can take up only on 9th. See, I am also a human being. I can take up only on 9th.
then, my lord, fix it. Let me come up on 9.
May His Lordship, I beg to mention for listing of a Abbey Lordship. Lordship matter may be fixed for Monday Lordship, 10 years punishment Lordship.
10 December.
Lordship, police charging him Lordship.
It's AB only.
Yeah, court Lordship.
AB.
Abbey Lordship, yes.
No, 10, huh? 10 December, no.
May I please your Lordship, I beg to mention item number 10 Lordship. The matter may be adjourned for the day Lordship. The engaged counsel is on leave and leave application has been submitted Lordship.
Learned Counsel Miss
Yes, Yasmin.
S. Yasmin has prayed for adjournment. List the matter after 1 week.
Week Lordship, he won't be
After?
available. 2 weeks
weeks,
Lordship,
okay.
after 12.
May I
Much
please,
obliged.
Lordship, I beg to mention item number 22. In this item, updated CD has been not received till now.
Updated CD as called for is not received. You have the CD?
Not received.
Is not received. Issue reminder. List the matter on 18
No,
December.
kindly this, on 11.
Yes.
Deeply.
May I please, your lordship? Lordship, I beg to mention item number 29. Okay, not for the day. 29. Consent has been taken from the other side.
So I am appearing for the appellant, Lordship. This is IA for suspension of sentence. Some urgency is there, Lordship.
Can it be fixed on 11th?
11, Lordship.
12 on 12.
12 is a
Suspension.
Friday, Lordship. 11 is a hearing day, Lordship.
No, it's okay. Suspension of sentence. It's
Orders.
not very difficult. We can take up NI Act.
No, Lordship.
What?
It is under, Lordship, arms sec, Lordship. 27-1. But there is material, Lordship, for
অলপ খালি দিন এটা দি দিয়ক যিকোনো খালি দিন 16 December
16. Obliged.
item number
29.
Learned Counsel Mr. your name
Yes, sir. Yeah.
SOK on behalf of Learned Counsel Mr.
No, actually, I'm appealing for respondent number 2.
For the informant, Lordship.
Okay. For respondent number 2 appearing for respondent number 2 has on behalf of who and SOK.
Myself, I am appearing.
He's
for
SOK,
respondent
yeah.
number-
Okay. You
Myself,
are
SOK, yeah.
Learned Counsel Mr. SOK on behalf of appearing on behalf of respondent number 2 has prayed for adjournment. Learned Counsel Mr. N. Hassan is
Lord.
present.
Lord applicant.
Additional PP Mr. G. K. Bosho is present. Leave this matter on DDR date.
16, Lordship. Obliged.
Also, I beg to mention for listing of a bail application for withdrawal on tomorrow, Lordship.
May I please, Lordship? Lordship, I beg to mention item number 35 of the supplementary list. Kindly adjourn for the day, Lordship.
A request for passover for the day is made. List this matter on after 2 weeks.
Obliged, Lordship.
Hey, Your Lordship, I beg to mention for listing of a criminal petition in the orders column, Your Lordship.
15
Let
December.
it be on Monday, Tuesday, or Wednesday, any date, Your Lordship. Only for the orders column,
Yes, yes.
Monday, Tuesday, Wednesday.
Monday, Tuesday, Wednesday, yes.
Any-
15 December is Monday.
Okay, thank you. Much obliged.
Item number 1.
11. Please, Your Lordship. Lordship, charge-sheeted case, Your Lordship, TCR may kindly call for Your Lordship.
Okay.
Total custody 5 months, 11 days, Your Lordship.
Call for the scan copies of the, call for the scan copies of the trial court records. POSCO?
No, husband-wife matter.
Okay.
Date 17 December. Obliged.
Call for the scan copies trial court records along with the scan copies of the CD.
May please, my lord. My lord, FIR on page 10, my lord, whereby informant stated that her daughter, aged about 16 plus, my lord, went from his home and till then, my lord, she not returned to her home, my lord. That is the allegation, my lord. Page 10, my lord. This is the
Page
FIR.
10.
Yes, my lord.
Under which sections you are booked?
87, my lord. Only 87 section is there, my lord. Now, lordship, come to page 6.
You're behind bars for how many days?
30 days, my lord.
Huh?
Today, 30 days.
30 days.
Lordship may come to page 16, my lord, where the initial preliminary investigation of the police, my lord, where it was, sir, I have the honor to respect during the preliminary inquiry, it is found that the missing girls, namely so-and-so, went away, not kidnapped, my lord, went away with the Rahul Ali, phone number so-and-so, for marriage with him, my lord. This is the, my lord, preliminary inquiry.
But has he been recovered?
Yes, my lord, I have the order, my lord, my lord.
Why you're giving it over the
My lord,
board?
subsequently we collect this, my lord, so we put up, my lord. Lordship may keep it with recording. My lord, second line, my lord, I have seen the prayer of the IO for the recording the statement of the victim under section 183 in connection with the notice.
Okay.
And from the bottom.
Just check.
Lordship.
Check with it.
Yes.
My lord,
Sir, attack over there. Third, Mr. Your name?
KM Hassan.
KM Hassan, learned counsel for the petitioner, so-and-so who has filed this application under section, he is behind bars, no?
Yes, my lord.
For 30 days, 483 of the BNWS 2023, with prayer for bail as the petitioner is behind bars since the
5/11/2025.
in connection with so-and-so PS case under so-and-so sections. Heard Mr. MP Goswami, learned edition PP Assam, who stopped, it is submitted the day inquiry report of the IO.
Yes, my lord.
IO or any other police officer.
Any other place of the scene. That's not.
That the inquiry report depicts that the victim went away with the.
In the IO, my lord.
Went away with the inquiry report depicts that the victim went away with the petitioner on her own volition. You have what is the annexure number here?
Annexure number, my lord, 2, my lord. Annexure 2.
The inquiry report is a part of the annexure number 2. Submitted along with the petition. Heard Mr. MP Goswami.
My prayer, my lord, that I have requested for calling the CD, my lord. It kindly be recorded.
As he has raised objections stating that the CD may be necessary to consider the bail petition, full stop. However, I have considered the submission that the victim has already been recovered and her statement has been recorded by the order dated 5/11/2025. Full stop. A copy of the order of the learned court, Elaka Magistrate, a copy of the order of the learned Elaka Magistrate has been submitted. This Elaka Magistrate or CJM? JMFC? JMFC, Elaka Magistrate has been submitted, which will form a part of this record. So it appears that bail may be granted to the petitioner who stopped. The petitioner was behind bars for days, an investigation may have presumably progressed substantially. Full stop, the petitioner is a local resident and is not a flight risk. Full stop, the petitioner has pledged to abide by any stringent bail conditions if imposed upon him. Considering all aspects, the petitioner is enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the the jurisdictional court Elaka magistrate under the condition that the petitioner shall not exercise threats to the witnesses and the petitioner shall cooperate with the remaining part of the investigation. On breach of any of the bail conditions, bail order, the court is on breach of any of the bail conditions, the court is at liberty to cancel the bail granted to the petitioner.
My lord, said order may cap with record, my lord.
Yes, it will be kept with the record.
Obliged, my lord.
Yes, yes.
Lordship, it is a regular resolution. There are two affairs in this case, Lordship. The both cities may be referred to.
Both cities, under which section?
Under section 109 of BNS.
1182, madam,
One-
previous heard, madam.
Do we want both the cities?
May not be, madam, only, may not be required, we cannot say this.
May be required, Lordship.
Okay,
Kiman, I,
call for a case diary of
itu Kiman?
Shampoo PS case number 20 or 21.
call for a case diary of
Shampoo PS case number 20/25,
as well as the case diary of
21 of 25.
list the matter on what PS case number?
Shampoo.
Shampoo from Dorong, madam, Dorong district.
It will take some time, at least 10 days.
It-
Can it be Lordship 15?
It won't come. Can be 15 December. It won't come. Okay.
Item 4.
May I please, your lordship?
Yes, sir.
Regular bail application, my lordship. Charge sheet case, my lordship.
Mm.
Here, my lordship.
Under which sections?
That's it. will take
We'll
two.
need the CD 103.
Here, my lordship, it is that petitioner was granted default bail. Page,
No, we'll need the case diary. He was granted default bail.
yes, my lord.
Then we will need the LCR. Charge has been submitted.
Yes, charge sheet.
We will need the LCR. This is murder case. Call for the scanned copies of the trial court records along with the scanned copies of the CD. List the matter on. From which police station?
Dibrugarh police station.
Time lagi, what time lagi? 17 December.
Item 5.
Pass of them.
May I please, your lordship?
Mm.
Lord, FIR at page 8, your lordship. The government has acquired some plot of land.
Mm.
Land of the present petitioner as well as the informant, adjacent land to the petitioner.
Please read the FI.
It's long FIR, my lord,
Mm.
at page operating part,
No, you read
No,
the
no.
FI.
FIR 13, your lord,
You please read it.
13 onwards.
Okay.
It won't take time. Please read it. Mm.
FIR name accused are two persons.
Mm.
Number one, Habibur Rahman.
Mm.
He earlier approached this honorable court and your lordship has granted bail.
Okay, if I haven't position.
Read the FI.
Page 13, your lordship. The complainant brief of the case.
Mm.
Para number one. The complainant along with his brother Bohiot Ali, son of so-and-so, that is witness number one, and Abdul Hakim Sheikh, witness number two, are jointly owned and possessed a plot of land measuring 1 bigha 1 kata 19 lesa, covered by patta number so-and-so, dag number so-and-so, situated at village so-and-so, under Revenue Circle, Dhubri, district Dhubri, Assam, by constructing dwelling houses and planting trees thereon. That the competent authority, Land Acquisition Deputy Commissioner's Office, Dhubri, has acquired a part of the said plot of land measuring 3 kata 5 lesa for construction of 127B number National Highway connecting to Dhubri Fulbari Bridge by LA case number so-and-so, and compensation against the land measuring so-and-so
House structure and fees assessed at rupees 6,68,722. But award number 258 and package number 2 and issued acquisition notice, award payment notice to the landlords, that is Ohiot Ali, Bohiot Ali and Abdul Hakim. That after receiving the said notice, the complainant along with witness number 1 and 2 visited the office of land acquisition branch of DC's office. They for withdraw the compensation amount against the said acquired land, house, structure and trees. And on inquiry, it is found that accused number 1, accused number 1 is the father of the present petitioner, making conspiracy with the accused number 2, illegally and fraudulently shown him, accused number 1, as owner of a house, structure and trees standing on the said land belonging to the complainant. And witness number 1 and 2, and on the basis of false field verification report, survey report submitted by the accused number 2, on 5/9/23, falsely showing the accused number 1 as owner and of a house, structure and trees standing on the said land on award of rupees 1,77,950, valued of rupees, house rupees 1 lakh.
So why she is apprehending arrest?
My lord, she also possessed some portion of land with her father, and that portion is also acquired. So she received some amount of award. So the police is asking her to appear before the police station in the interest of investigation. My lord, page 18 is your lordship order granting bail to the accused number 1, that is the father of the present petitioner, your lordship. My lord, I will appear before the investigating officer, your lordship. Totally civil dispute, your lordship. And the government authority, after following all formalities, they have acquired the land and released awarded money.
Yes.
Let him appear, madam. After application.
Our learned counsel, Mr. E. Hussain.
A. Rahman.
Mr. A. Rahman for the petitioner Sahida Bibi, who has filed his application under 482 of the DNWS 2023 with prayer for PLS bail as she is apprehending arrest in connection with so-and-so PS case under so-and-so sections. It is submitted on behalf of the petitioner that the petitioner has received compensation for her own plot of land and not for any plot of land as alleged by the complainant for her own plot of land and not for any plot of land belonging to the complainant as alleged by the complainant against the father of the petitioner, who is named as accused number 1 in the complaint petition. Okay, he is accused number 1.
Accused number 1.
It is submitted that the petitioner's father has already been granted interim bail, and on the ground of parity, the present petitioner, who is a woman, may also be granted bail as the petitioner is willing to cooperate with the investigation. Full stop. Heard Mr. MP Goswami, learned addition CP Assam, who has raised serious objection against the prayer for interim bail. I have considered the submissions at the bar. Full stop. I have considered the submission that the petitioner is willing to cooperate with the investigation and to abide by any stringent bail conditions if imposed upon her. Full stop. The petitioner has admitted that she has received certain amount of compensation and she is willing to appear before the IO and cooperate with the investigation relating to the money received as compensation. Full stop. It appears that there are sufficient grounds to grant interim bail. Call for the city, list the matter on. In the interim and in the event of arrest, the petitioner shall be allowed on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation. The petitioner shall appear before the IO on every fortnight till completion of investigation. The petitioner shall not leave the jurisdiction of the court without prior permission on breach of any of the bail conditions. The bail order shall stand automatically cancelled.
Previously for this item 54.
My lord, this is also out of the same FIR.
Mm.
This petitioner is Lat Mandal. He submitted the report after field verification. And
এইটো এনেকে লিখি দিবা তাৰপিছত লিখি দিবা যে the present petitioner একেখিনি লিখি দিবা খালি ইয়াৰ ষ্টৰিটো অলপ বেলেগ হ'ব তাত ভৰাই দিবা the present petitioner is a Lat Mandal and he has submitted the report full stop. The petitioner is willing to cooperate with the remaining part of the investigation full stop. He has admitted that he has submitted the report full stop. Although the objection has been raised by the learned additional PP Mr. MP Goswami, it appears that as the petitioner is willing to cooperate with the investigation, interim bail may be granted to the petitioner.
Right, must oblige.
Allegation to all eighteen, but he below others other everyone looking.
This item 6 for also.
May I please, your Lord? No, this petition preferred against the ex parte order on family court. But your petitioner is a CRPF Jawan, my lord. So the respondent filed the case in the family court, but he never received the notice. Because during that period, COVID lockdown was there, he was not given leave from there and he had never received and
Yes, we will issue notice.
my lord, notice na
Learned counsel, Mr.
MK Boro.
MK Boro is present for the petitioner. First of petitioner to take steps to issue notice to the sole respondent.
My lord.
To the respondent number 2, returnable within 4 weeks. Learned additional PP Mr. MP Goswami is present for the respondent state and has accepted notice on behalf of the respondent number 1 and thus no formal notice is required to be issued. Stop. Extra copies to be furnished. List accordingly.
My lord, furthermore, may I pray one of the operation of the.
No, no.
May with us.
He's a CRP Jawan, come on.
Well, only his service has always been
No. CRP Jawan. At least 50,000 he is earning every month.
No, he has been removed from service, my lord, due to this case.
Due to this case, how can he be removed? This is only
Well,
125.
Yes, my lord, the warrant were issued to him to the headquarters and headquarters removed him.
Dismissed
Remove him.
from
Yes,
service.
remove from service.
Suspended.
Remove, my lord.
You, on the exit, you bring the order of termination.
Remove, my lord.
Have you brought it today?
No, no, my lord. I
Have
don't.
you mentioned it in the petition?
No, my lord. At that time, he was.
Then
not.
like the.
Subsequently, he was.
For the trial court records.
My lord.
You bring the order of suspension, then we may consider.
No, my lord.
But you must, I think you better file it through an IE
My lord.
or through an
I will
additional
take an
affidavit.
My lord. May I please?
Mm.
This is against conviction, the revision may be admitted at this state and CR may be-
Admitted. Can I?
Can I?
You'll have to pay 20%
20% I have already paid
Paid.
the appellate court.
in the appellate, before the appellate court.
Before the appellate.
Okay. Where, in which paragraph of the petition have you mentioned?
This order I have, next, last, this order I have,
Oh, then it's good enough.
page 74, my lord.
Page 74, okay.
Last page.
Last page, okay. This is 20% of the compensation amount?
Yes,
Learned counsel, Mr. A.I. Uddin is present for the petitioner. Mohammed Imtaz Ali, alias Imtaz Ali, who of the petitioner has filed this application under section
230.
438 stroke 442 of the BNSS 2023, read with Article 227 of the Constitution of India, Constitution to C to capital लिखना ठीक और I to capital लिखना. The petitioner is agreed by the judgment and order dated 31/10/2025 passed by the learned session judge Golaghat in criminal appeal number 24 of 2023 and the judgment and order dated 17/8/2023 passed by the learned SD Jain M. Dhansiri at Surupatra Golaghat in connection with CR case CR within bracket capital NI bracket close case number 1 of 2021, convicting the petitioner under section 138 of the NI Act and sentencing him to undergo simple imprisonment for a period of 6 months and to pay a fine of rupees 3,80,830. Full stop. Heard Mr. MP Goswami, learned additional CP Assam, who has accepted notice on behalf of the respondent state, and thus no further notice is required to be issued. Full stop. Extra copies to be furnished. Full stop. The petition has prayed for suspension of the operation of the impugned order of conviction and sentence. And also previous bail.
Yes, on previous, I am already on bail.
Oh.
So I mean,
And eto duta mix.
I have filed separate I have.
Okay. Eto I to likhibe. And also duta ekalage likhibe.
Page 7.
I to issue notice likhibo nalage.
I dispose of it.
Hari issue notice to respond number 2 লিখিছিলে দিছো কৈছিল নেকি নাই কোৱা না নালাগে তেতিয়াহ'লে copies to be furnished to আছে না ইয়াত এইটো কাটি দি it will pass this order in the IA only that suspension of sentence. And also to remain on previous bail. It is also submitted that the annexure 8 of the criminal revision petition number 510 of 2025 clearly is a copy of the is a copy of the downloaded, no?
Yes.
Is a downloaded copy of the order
3/5/2024.
dated 3/5/2024, whereby 20% of the compensation amount has been received has been deposited by the petitioner in the appellate court. Post of as 20% of the compensation amount has already been deposited, the prayer for suspension of the impugned order of conviction and sentence remains suspended until further orders, and the petitioner is also allowed to remain on previous bail until further orders. In terms of the above observation, the IO stands disposed of. The criminal petition to Likha, Learned Counsel Mr. AI Uddin is present for the petitioner, and Learned Additional PP Mr. Anthony is present for the respondent state and has accepted notice on behalf of the respondent, and thus no further notice is required to be issued. Full stop. Extra copies yet extra copies extra copies to be furnished during the course of the day. Issue notice to the respondent number 2, returnable within 4 weeks. Also call for the records of the, also call for the original records of the, from the, of criminal appeal number 24/2023, from the,
Session.
and records of NI case number NI to within present 1 of 2021 from the respective courts. Original record original records to be list accordingly. Is it 5 minutes? Yes.
Lordship, in this petition, the petition is filed against the order dated 27/8/25, passed by the learned special justice Kokrajan in special NDPS case number 28 of 24, whereby The prayer of the petitioner was rejected. The Zimma prayer of the petitioner was rejected. The order is at page.
What do you want as Jimma? Vehicle?
Vehicle
carrying those contraband.
Okay,
Not
we'll issue,
press report.
we'll get a fresh report. Okay.
Lordship, it's been already
This
lying.
case is charge sheeted.
Yes, Lordship. Chargeable.
To call for because there are some parameters laid down, my lord, for releasing the vehicle under NDPS, my lord.
From whom you'll call the report?
Report, my lord, TCR will be,
Now charge sheet has been laid.
TCR will be sufficient, my lord.
TCR will be sufficient. Okay.
Lordship, I am the owner, Lordship. The driver.
Yes, it's okay. We'll just call for the trial court records and we'll consider. Okay. Call for the scan copies of the trial court records along with the scan copies of the CD. List the matter on before vacation.
Yes, Lordship.
18 December.
See, after that, this is at motion stage, no?
Yes, Lordship.
Can.
Obliged, Lordship.
Item 9.
May I please, Lordship, this is an application for quashing of an impugn order passed by the learned JMFC 3 of Kamrup Metro. In DV case, Lordship will find the impugn order at page 41, Lordship.
Yes.
Lordship, in this case, the petitioner, who is the aggrieved person in the DV case, she has been barred from filing her evidence on affidavit.
Please read the order.
Lordship.
Please read the order.
Yes, Lordship. The matter is fixed for PW's evidence. The respondent number 1 is present before this court personally today. The aggrieved is absent with steps by petition number 4589, stating that she is suffering from health issues and could not submit the evidence on affidavit today and has prayed for fixing another date for submitting the affidavit. The petition is accompanied by a copy of medical document. I have seen and perused the petition and the accompaniment. On such scrutiny of the submitted medical document, it appears that the document does not reveal the name of any patient, so there is nothing to show if the same belongs to the aggrieved. I have heard the learned counsel for the aggrieved on his submission, who has stated that the aggrieved is unable to walk and advised surgery, but due to lack of money, she could not undergo the surgery till date and hence could not come before the court, and another date is highly required to fix for evidence. Per contra, the learned counsel for the respondent has stated that the aggrieved has filed this case falsely just to harass the respondents and have been delaying the matter willfully and seeking repeated adjournments on each and every day. The counsel urged before the court to go through the case record for having an insight regarding the conduct of the aggrieved in the proceeding at hand heard. I have given my anxious consideration to the submission made by both the sides. I have meticulously gone through the case record, which reveals that wide order dated 22/8/2025, this court had given a last opportunity to the aggrieved to file PW's evidence positively today after allowing the adjournment on that day. And in spite of such strict direction, the aggrieved has failed to comply with the court order ever after 2 months. And instead of submitting the evidence, another adjournment petition has been filed today, showing the same held ground. Thus, considering the circumstances that have been brought before this court, I am of the opinion that the aggrieved has been dragging the matter without any cogent ground, and accordingly, I find it justified to reject the adjournment petition and also the prayer of the interim maintenance at this stage, since the aggrieved herself is not willing to do the needful in spite of getting ample opportunity. Lordship will find the last page of the impugn order in the additional affidavit that I have filed, Lordship.
Yes.
It reflects that the prayer of interim maintenance filed by the aggrieved thus stands rejected. The matter shall now be heard finally after closure of evidence of both the sides. Also, the aggrieved is barred from filing her evidence in this case, considering her.
So you want to, your prayer in this petition is to adduce evidence,
Yes, Lordship.
not more than that?
No, Lordship.
Okay.
I want to adduce my evidence, Lordship, since I am the aggrieved person of that case.
State is responded?
Yes, Lordship.
We'll send it, we'll allow only one last opportunity to adduce evidence. Evidence. And then if you don't turn up, then you won't get
Lordship,
any
we'll
other
back up.
opportunity. Learned Counsel Ms. S. Yasmin is present for the petitioner. নামটো লিখিব নালাগে. who has filed this application under section 520 of the BNWS 2023 with prayer for quashing and setting aside the impugned order dated 7/10/2025 in DB case number 236/2023 passed by the learned JMFC 3 Kamrup M. Heard Mr. MP Ruswamy learned additional PP Assam for the respondent numbers for the respondent state. Full stop. Notices are accepted by the learned additional PP and thus no further notice is required to be issued. This case is decided without issuing notice to respondent number 2 and 3. Full stop. The petitioner is aggrieved by the impugned order as the petitioner was not accorded an opportunity to adduce evidence. Full stop. It is submitted that the petitioner will be highly prejudiced if she is not allowed to adduce evidence. Full stop. The impugned order reflects that the petitioner was allowed. The petitioner was granted several opportunities to adduce evidence, but the petitioner failed to adduce evidence and a last opportunity was accorded when the petitioner again failed to adduce evidence. Full stop. The petitioner prayed for adjournment on the ground of medical ailment, and the Annexure 6 is a certificate relating to her medical ailment. Full stop. The certificate reveals that the petitioner was suffering from right TB and WA tear, but now she is recovering. Full stop. If the petitioner is not allowed to adduce her evidence, comma, the entire case will be infructuous. To stop. A pragmatic view is taken and a last opportunity and the petitioner is allowed to adduce her evidence. Full stop. On the next date fixed, the petitioner is directed to appear before the. When is the next date fixed?
23/12.
Okay, directed to appear before the trial court and adduce her evidence. Full stop. On failure of her on failure, necessary orders may be on her failure to appear and adduce her evidence. Necessary orders may be passed by the learned trial court. Full stop. The impugned order dated. What is the order dated?
7/10/2020.
7/10/2025 in connection with DB case number 236/2023 is hereby set aside and the petition is directed to appear before the court and the court may give allow one last chance to the petitioner to adduce her evidence.
I'm highly obliged.
In terms of the above observation, this petition stands disposed of.
But
May I please, Your Lordship? Lordship, the present application pertains to quashing of an FIR as well as a criminal proceeding. So before getting in the merits of the case, Your Lordship, I beg to mention that the matter has been amicably settled between the parties. So currently I'm serving in the Indian Army, Your Lordship. So the FIR is completely false and lodged out of emotional distress, Your Lordship. Informant has appeared and by virtue of an affidavit.
The matter has been amicably settled, Lordship, and I also filed an affidavit in that regard to the petitioner that no objection is there if the complaint is passed, Lordship.
No, we both have moved on in our life, and informant has got married to a different individual, Lordship. So my humble prayer is that you know that
This is a joint petition.
no, it's not a joint petition, Lordship.
PP.
Otherwise, my lord, it is a matrimonial, my lord, so matrimony side, they, my lord, introduced to each other. Later part, my lord, that is from their, both their home, my lord. There because that is the, from the groom's home, my lord, that is to be grooms, my lord.
Why
not
has
accepted.
come before this? Where is the place of cause of action?
You know, at the prevailing time, I was posted in Guwahati, Your Lordship.
Okay.
So the fact is that, you know, I
Now
came in
that
contact.
FIR was lodged in Guwahati.
Yes,
Yes,
yes.
Vasishtha Police Station.
Vasishtha Police Station, Your Lordship.
But because both of them are residents of Tamil Nadu.
Yes, Your Lordship.
One is
Currently,
staying
I'm posted in
Jammu.
Jammu and Kashmir, Your Lordship.
Okay, Vasishtha PS case.
Yes, Your Lordship.
Under which section? Just let's.
You know,
speak-
406, 417, 418, 294, 293, 506, and 507.
You have the any judgment?
Yes, Lordship.
Lakshmi Narayan or any judgment will work.
I'll place it, Your Lordship. Yeah. Sure. Very well. Submit Pinko and Pinko.
Third learned counsel, Mr.
Yes, Your Lordship.
R. Yasin for the petitioner. नाम तो लिखियो ना लगे हाँ. For the petitioner who has filed this application under section
406, 417, 418, 294, 293, 506, and 507.
let us see.
Application under matter 528 matter of BNSS.
Under section 528 of the BNWS 2023 with prayer for quashing the only FIR, anything else?
FIR and criminal
Entire
proceeding.
proceeding matter.
Entire proceeding, Your Lordship.
Quashing the proceeding of PRC case number 1226 2025 arising out of Vasishtha PS case number 595 2023 under sections. Please.
406,
Likha.
417, 418, 294, 293, 506, and 507.
Heard Mr.
AJ, Lordship. for-
K. Jain, learned counsel for the respondent number 2 and learned counsel, learned additional PP, Mr. K. Bishop for respondent number for the respondent state, full stop. It is submitted by the learned counsel for the respondent number 2 that this matter has been amicably settled between both the parties.
One affidavit is my lord annex. It is annexure 2, my lord, page 20, my lord. In this regard, from the end of the respondent, my lord, informant.
The respondent number 2 learned additional PP has also submitted that the annexure 2 of the petition. I'll mention your name here.
No, my lord,
Not
it is on
required,
the
now.
record, my lord.
The annexure 2 of the petition, learned additional PP are submitted. The annexure 2 of the petition is an affidavit submitted by the respondent number 2 that he has amicably settled the dispute with the petitioner and she has no objection if the if the entire proceeding is quashed, as she is not, entire proceeding is quashed, as she is not interested to proceed with this case. Allegations of serious cruelty and harassment petitioner by the respondent number 2 along with allegations of misappropriation of street hunting.
No, we are not married. We,
Okay.
I came in contact with the informant through a defense
Not
matrimonial
married.
website.
That marriage was not.
Marriage was not solemnized.
Not solemnized, my lord.
Then why 406?
No,
Into allegations of serious cruelty to Katidia. Where is the FIR?
FIR is at page 11, Your Lordship.
Please read the FIR.
It's a long FIR, Your
You
Lordship.
will have to read,
3 pages.
we'll have to give the gist of the FIR.
The informant was working in IT firm currently, work from home. I met so and so. the so and so, in a matrimony of 2022, May we started talking on the phone. We link each other. He promised me for marriage as he is posted in 58 Ford Medical Depot, Guwahati, Assam. To know each other, we wanted to meet up. So I went to Guwahati in the month of August 13, 2022 and stayed there up to September 11, 2022. In the whole month, he took 12 days leave from his duty and stayed with me in the independent house he took for me. In his leave days, he took me to Meghalaya, Shillong and Cherrapunji. The independent house he rented mentioned that I am his wife. We stayed in his army JCO guest house Shillong on August 19. There also he mentioned I am his wife. We were in good relationship until opening up his parents came into picture. I was requesting him to talk with his family as he has some bad debt before taking to them, wanted to close all on top of his sister marriage, having some problem. He went into depression due to that. As peace of mind, he wanted to go to so and so before he put so and so he wanted to meet me. So I went to Guwahati in the month of November 11, 2022 and returned back.
Lordship, you want to submit on the entire,
Lordship,
this is for admission, you want to submit?
Lordship, at this stage, you may not allow Lordship.
No, because you see, you have to file an IA if you want to
Oh.
withdraw the amount.
My lord,
Although you
My-
file an application in the trial court, where have you deposited the
my
amount?
lord deposited before this honorable
Before-
court, and it is,
I- You file an IA.
my lord, I will file, but my lordship, if possible, my lordship,
You file an IA.
my lord, if possible, lordship may pass the order in.
No, no,
My lord.
not in this, not like in this manner. File an IA. Even in MSCD cases, they are filing an interrogatory application for withdrawal.
My lord, order has been passed in the revision petition to deposit. Accordingly, they have deposited, my lord. So, my lord, since the order is,
In revision petition, in every revision petition, order is passed.
my lord,
to
since
deposit
the order,
amount.
main order is here, my lord. I think, my lord, lordship, if lordship may pass the order in the revision petition, only one observation that after proper investigation, my lord, the check may be disbursed to the respondent. That observation. Otherwise,
Why you file an IA?
my lord, I will file, my lord.
You file, pass the
My-
order, I am giving you my word, I'll pass an order.
On Lordship and the record may be called for.
Records have been called for. Records have been called for.
Record, I think record received, my lord. There, my lord.
No, records are not received.
My lord, in the last, my lord, in the brief, my lord, in the last part, my lord, main brief, my lord.
Oh, no, records are not called.
Yes.
Only the,
Lordship, may I pray for revision petition may be admitted for hearing, record may be called for. In the meantime, he will file
Aye, yes.
interlocutory applications.
only this is not admitted,
May I be fixed for admission hearing, my lord?
we'll fix it for hearing altogether.
My lord,
Huh?
Lordship.
my lord.
In
It may be
admission,
fixed,
it is not required to be fixed for admission.
no Lordship. It
On
may be
the
fixed for a
admission,
hearing, final
you can
hearing.
dispose it of.
Today,
Lordship.
it is listed for admission already, my lord.
it's
So, my lord, I will file an IA, my
It
lord.
may be admitted for final hearing, Lordship.
My lord, not
For
necessary,
hearing.
because at the admission stage, it may be disposed of, my lord.
Dispose it of
Dispose of, my lord.
admission.
So, I will file an IA, my lord. On the next occasion, IA may be considered. my lord.
Learned counsel, Mr. L.R.
Yeah,
Muzumdar is
yeah.
present for the petitioner and learned counsel, Mr.
Yeah, Ali, my lord.
A. Ali is present for the respondent. Number 2, comma, whereas learned additional 50 Mr. K. Bush is present for the respondent state, full stop. The call for the trial court records, final disposal, no, judgment and order.
My lord.
Lordship.
Call for the trial, call for the original records of criminal appeal number 5 of 2022 and CR case number 757 of 2018 from the respective courts. List this matter in the admission column. Okay. You'll have to file it because there's nowhere in the
Admission column, my lord. I will file an IM.
Because nothing, nowhere it is mentioned about withdrawal. In the order also, or in the prayer also, nowhere you have mentioned for withdrawal. Something has to be there.
My lord, I think, may I request, my lord, may I approach registry, my lord, to hand over the check, my lord, to the respondent, my lord. Then, my lord, IA will not be required, my lord. May I approach, my lord?
No, registry will not hand over without an order of this court.
I will
I
file
don't
an
think
IA.
so, yes,
Yes,
you'll have
yes.
to file an IA. 1, 2 paragraph. you'll
My
have
lord,
to
my lord,
write.
I'll definitely, my lord, I will file.
Uh, 4 weeks?
For in the month of January, my lord.
List this matter immediately after the vacation.
My lord.
Immediately
Yes,
after.
yes, yes.
Right.
Actually, report was called for from the IO, whether my brother is.
My lord, that Zimma report is awaited, my lord. We are
Mm.
going to pray for some time, my lord.
Okay, sometime, 1 week?
Already for 11 weeks, it is 11 months. 11 months. Right, is lordship, please, can it be on
Report has
18th,
called for-
lordship?
Huh?
Just
Can
before
be.
the vacation.
Report has, yes, can be. Report is called for
It-
is not received. List the call, issue reminder, list the matter on 18 December.
Diplomatized.
Item 17.
My lord, in this case, I am appearing for the sole respondent, my lord. As per this honorable court's order, last occasion, my lord, lordship, the proceeding was stayed, my lord, subject to condition that the payment should be continued, my lord. That order is there, my lord, as per order, my lord, 14/7/2025. So since the stay is there, my lord, they are not paying, my lord.
They have not appeared also.
My lord. So, my lord, if the stay is continued, my lord, the payment may be continued, my lord. Because earlier also they did not pay till now, no single amount, my lord. So the petition respondent is a very financially poor, my lord, with his minor daughter. Some problem is there. They are not appearing.
See, we will vacate the stay, but you will have to file an IA again. Yes,
Yes.
you'll have to
I-
file an IA again and then you'll have to issue notice to the other side.
Okay.
We'll vacate the stay.
Yes,
The
good.
petitioner is not represented today. Learned Counsel, Mr. M. Islam, no?
AL.
So Mr. A. Ali is present for the, we have state also
No, my lord. No.
for the respondent and has submitted that after procuring an order for stay, the petitioner has stopped payment payment of rupees 6,000 to the respondent per month, full stop. It is further submitted that the petitioner has been granted stay subject to the condition that he has to pay rupees 6,000 to the sole respondent per month, full stop. Today, the petitioner is absent. List this matter list this matter on
My lord, some urgent date, my lord.
on
Right.
failure of appearance of any of the parties, necessary order may be passed.
My lord, matter may not be fixed. I will file an IA, my lord. Thereafter, it will be, my lord, listed for orders, my lord. May not be fixed, my lord.
Okay,
My lord,
list this matter after 2 weeks.
my lord.
Oh. I'll come back after 5 minutes. Huh?
An appeal may be admitted, record may be called for.
We'll admit it.
Next word, POCSO notification, Lordship.
IA will have to issue notice.
Yes.
Appeal will admit, criminal appeal.
Notice will go in both the matter, ma'am. Admit, but my lord, notice will go in
No,
both.
yes.
Yes, yes.
Learned Counsel, Mr.
SK Chetri.
S.
SK Chetri.
K. Chetri is present for the, SK Chetri is present for the appellant, Mohammed Rahim Ali, who is aggrieved by the judgment and order dated.
Challenged some orders. Now, we have also filed a case against them. But learned magistrate, instead of clubbing both the cases together, has started trying only the case of respondent, and my case has been sought to be tried separately. Now, our High Court has a decision that if there is a
Cross case.
cross case between the same parties for the same subject matter, both the cases should be heard together. But that is not done. That is also our grievance. So that's why if Lordship may kindly call both the records, then I think it would be better to understand.
May I submit, Your Lordship? With due respect, Your Lordship may kindly peruse the prayer of this particular petition. They are challenging a order. Your Lordship may kindly peruse the prayer of this petition, Your Lordship, at page, page 12, Your Lordship.
Yes.
May I read, Your Lordship? In the premises aforesaid, it is therefore paid that Your Lordship would be graciously pleased to admit this petition, call for the records, issue notice to so cause as to why the judgment dated 2/9/2025 passed in criminal division number so and so, and the order dated so and so passed in CR case number so and so passed in learned CJ and Cockroach shall not be quashed and set aside. Now, these orders, Your Lordship may kindly peruse. These are two orders, but before that, Your Lordship may kindly peruse page 47. This is the order, 26/9/2024. Now, why this order has been passed, Your Lordship? Because of a petition, they have filed two petitions in this regard for examination of the check. Your Lordship may kindly peruse page 46 for a moment. Page 46, if Your Lordship kindly reads. Page 46. I'm starting from the word hence. It is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 line from 10 line, Your Lordship. Hence, the complainant being the custodian of the said check, due to his mala fide intention, he himself returned rupees 80 lakhs and put his name on the check. So the check bearing number so and so issued on 2/4/2024 may kindly be sent to the director FSL Kahilipara, Guwahati for examining the writing of the name of the complainant on the check as well as the writing of amount and date on the check. Otherwise, the accused person will suffer loss. It is also paid that till examination of the above writing on the check, the further proceeding of the case may kindly be state is also informed by the accused. So this is the fact, Your Lordship. Against that, the order has been passed in 29/6/2024. Before that also, they have filed a petition for stay. Now, Your Lordship may kindly peruse page 47. May I read, Your Lordship? Accused is absent with stage 5 petition bearing so and so cause, showing cause of his presence, absence, prayer is allowed. Seen petition number so and so filed by the accused praying for sending the check bearing so and so to the director of official Kahilipara, Guwahati for examination of handwriting of the same name and amount written in the check. Also seen petition number 1172 filed by the accused praying for staying further proceeding of this case until getting examination report of the check bearing number so and so for FSL. Hard peruse the case record. Learned advocate for the accused submitted that the name and amount reflected in the check are not written by the accused but by the complainant himself. Learned advocate for the accused also admitted the signature of the check was that of the accused. He also contended that the accused had no liability of the amount stated in the check towards the complainant. Your Lordship may kindly note, Your Lordship, the allegation is not about the genuineness of the check or overwriting or alteration. They are only stating that I have written it. Necessary to be decided whether name and amount in the check was written by the accused or not. Otherwise, the accused will be prejudiced. Learned advocate for the complainant submitted that there is no necessity of examining the name and amount of the check is written by the accused or not as the check bears the due signature of the accused. The case was filed under section 138 of the NI Act. On perusal of the exhibit 6, the check in question as admitted by a learned advocate by accused, the check was duly signed by the accused. Once the check is duly signed, it is not material who has written the amount and the name in the check, as there is a presumption under section 18 of the NI in this regard. As submitted by the learned advocate for the complaint, Honorable Supreme Court in Oriental Bank of Commerce versus Prabodh Kumar Tiwari observed the fact that the details in the check have would be immaterial. The presumption which arises on the signing of the check cannot be reverted merely by report of handwriting expert, even if the details of the check have not been filed by the drawer, but by another person. This is not relevant to the defense whether check was issued towards payment of a date or in chargeable liability. In view of the above, this court considered that by sending the check for official examination for the aforesaid purpose will not help in any way the defense, but would cause unnecessary delay to the proceeding. Hence, the petition bearing number so and so are hereby rejected. Against this, they have filed a revision, Your Lordship. The order is at page 53. May I read, Your Lordship? I'm reading from page 55, Your Lordship. Upon going to paragraph 5, you have Your Lordship got it, Your Lordship. Paragraph 5. Upon going through the impugned order dated 26/9/2024, it appears the check in question, which is exhibited as Exhibit 6, was duly signed by the accused. The trial court has stated that once the check is duly signed, it is not material who was written the amount and name in the check, as there is a presumption under Section 18 of the NIAC in this regard. Therefore, sending the check for official examination of the name and amount written in the check will not help in any way the defense, but would cause unnecessary delay to the proceeding. Learned Counsel for the respondent number 1 has resided on the decision of the Honorable Supreme Court in case of Oriental Bank of Commerce versus Prabodh Kumar Tiwari, reported in AIR Online 2022 SC 1365, when the Honorable Supreme Court has held that the presumption which arises on the signing of the check cannot be reverted merely by the report of the handwriting expert, even if the details in the check have not been filed by the drawer but by another person. This is not relevant to the defense, whether check was issued towards payment of a debt or in discharge of a liability. Similarly, in Bir Singh versus Mukesh Kumar, it has been held by the Honorable Supreme Court that if a signed blank check is voluntarily presented to a payee towards some payment, the payee may fill up the amount and other particulars. This is itself would not invalidate the check. Thus, the settled position of law is that the payee may fill up the amount and other particulars in the check, and the check is not invalidated for the reason that other particulars in the check have not been filled up by the drawer. In the instant case, there is no dispute with regard to the signature in the check. The accused petitioner has admitted his signature in the check. Therefore, I find no sufficient ground for sending the check for forensic examination of the handwriting of the name and amount written in the check. The learned trial court committed no illegality or irregularity by rejecting the petition filed by the accused petitioner. Against this, Your Lordship, they have filed the next division, Your Lordship, on the same ground. Same ground, they have filed a 482, Your Lordship. Now, Your Lordship may kindly.
No, they can file.
Yes, definitely they can file, Your Lordship. May I, Your Lordship? I'm relying on certain judgments of the Honorable Supreme Court, Your Lordship, in this case.
Actually, my lord, actually I wanted.
I think the records are not required, I think.
Yes,
My
Your
lord.
Lordship.
I agree with him. I don't think records are required.
My lord,
I'm-
my submission is this, my lord. Everything is for the ends of justice. Now, our two petitions were there. One was for further proceeding. Another was to send the check to the FSL expert. Now, and we also clearly stated in our petition that we are ready to bear the expenses. That Worship may kindly say, page 46.
It's okay, but I think it's not required.
Not required, my lord. Another
I don't
thing, my
think
lord.
it is required.
No, that is it is a question that in how and what manner the writings were made by another person. That may be made. But thing is that, my lord, to that regard, I have every right to question regarding who write this and what.
Help you improve your case. You can question, you can prolong the case, but it won't help you improve
But
the case.
another thing is here, my lord, there is cross case. And the cross case has been sidelined. So both the cases should be tried together. Our High Court has a decision, my lord. May I read just this?
In my respectful submission, Your Lordship, they can raise this point before the learned court when the
No,
case
that-
is pending.
that-
Here in
that
this
would-
case, Your Lordship, they have very specifically questioned the order.
Into-
Exactly, Your Lordship. That is the point.
My lord, kindly note down, 2005 1 GLT 132.
We have this Supreme Court's or judgment also. Misread.
Yes, Your Lordship.
That cases have to be clubbed together.
Yes,
We
Your Lordship.
Yes.
Judgment.
That's
Your Lordship.
You give me your citation, 2000,
2005 1 GLT 132
2000,
5 1 GLT 132 para my lord 18 19 20 22 23 24 and it is also Supreme Court AIR AIR 1980.
What is the name of the parties here? JLP?
That is name of the parties is Sadat Ali and others versus State of Tripura.
You see, this is not required here. You have no prayer
Yes,
to
Your
club the cases together.
No, Lordship, our.
If you don't have the prayer, how can I club the cases together?
Exactly.
That is.
And Your Lordship, one more important point is that whether the second revision is maintainable in the present
No,
factual circumstances.
second division.
This is a second revision that has,
Second
yes, Your
division
Lordship, because of the
maintainable.
same faction.
It
No,
is-
yes, Your Lordship,
No, it-
the Supreme
that
Court,
is-
Supreme
No,
Court.
no, this is
Where
not.
it is
Your
here.
Lordship, but on the same faction circumstances, the Supreme Court has made it categorically clear that they cannot prefer a second revision under the garb of, because the same prayer is there, Your Lordship.
Can you
Lordship,
say page 11, madam? Page 11 of our petition. Page 11, para E. Further, the petitioner has also a counter case, being complaint case number 49/2024 for the same cause of action, and the said involved the same set of parties.
But your prayer, you have, that is a submission, but you have not prayed.
It is in record, man, in petition that is there. But
Why-
even then,
why-
my lord, law,
why beyond your-
my lord, law point may be raised, though
No,
it is not especially raised, law point may be raised even up to the Supreme Court, my lord. Because of non-mentioning,
no,
in
this,
the,
this is, you see, when you affect the parties,
yes,
then it has to be prayed. But here, any order may be passed. But this will affect the parties, then this has to be prayed.
then lordship kindly allow me some, I will file an additional affidavit, because that is, unless both the cases are taken up together, justice will be denied to the present petition. So in the interest of justice, we will face the trial, we have no.
This is at the administration stage, how can you file second additional affidavit?
Admission, that is why I pray that lordship may kindly admit the matter and call for the both the records. Both the records, then you lordship would see what has happened. Actually, these are the result of some extortion, threat and coercion, all these things are there. Otherwise, I am a poor man, what is the legal liability? I have no capacity even to maintain my family, 80 lakhs. So that was taken under duress and threat by the respondent. And respondent is having top political power in his backing. And respondent, lordship, respondent is Amal Narjek. He has so political power. So he is doing all this under threat, coercion, and all these things. 80 lakhs, I am not a man of 80, 100. And he has written this amount. So, my lord, may I kindly admit the matter. A shorten may be fixed. I do not want to delay. And thereafter, both the cases may be called for. And thereafter, lordship may pass the order.
may I submit the judgments, Your Lordship, if Your Lordship may kindly allow.
The judgment I may also submit, but I wanted that if the records are called for, then it will be better to understand. You will be also able to answer my submissions.
Because they,
He made an agreement with me for 3 years. Just after 3 months, he has taken everything.
well, learned friend, Your Lordship is making submissions that they may be made in the trial court, Your Lordship. We are not in trial. Here, the only question that needs to be decided, Your Lordship, is
So
that
where is the
whether,
case?
no, this is not about the cross case, Your Lordship. They have a specific prayer that the check needs to be sent to the forensic laboratory. That particular prayer was rejected. They had filed a revision. That was also rejected. After that, they have come before this honorable court.
That is
In this case, Your Lordship, there are specific, Your Lordship may kindly peruse a judgment for a moment. It will make everything
No, it's
clear.
okay. I understand.
Yes,
They
Lordship.
cannot take the plea over and over again.
Exactly,
Yes.
Lordship. That is my point.
That is correct.
So that is the,
But my submission is both the cases. Today wants to decide, I have no objection, provided both the cases may be tried together, so that the matter can be properly adjudicated. Otherwise, he will take one-sided and my case is sidelined. So if to that extent, I do not know why my learned friend would object to this, because there is cross case and both the cases should be tried together and everybody would be able to raise his grievances. But if only one case is taken and my case is sidelined, then what will be the happen?
So, see, very short relief. I dismiss it and then I'll pass an order to try both the cases together, or you want to place your submission?
Yes, but that, but no, in lieu of dismissal, dispose of, my lord, that way.
That both the cases together?
Yes, sir, yes, sir. I have not.
That can be done, your lordship. They can make a prayer before the honorable
No,
trial court, but the trial is
that-
pending, your
that was
lordship.
made. That was made. That's why I wanted.
That
That is why I wanted to call for the records. Now, what my lords had proposed, I have no objection. Only dismissal may bring a wrong meaning, so disposed of, and both the cases may be tried together. I have no objection. And it is in the interest of justice. It is the most reasonable order.
Oh, without dismissing?
Yeah, only on dismissed that one disposed of or closed.
On merits.
This was the learned court below would take both the cases together and will dispose of both the matters in accordance with law. That's it.
What I understand, your lordship, in my respectful submission, your lordship, they can raise their defense at the time of when the 313 statement has been there, or they can also give their defense witness.
That is the
And
last
one more thing, your lordship, the other trial, your lordship, maybe there is an allegation against me in the other trial, your lordship, but that can be tried together. But this case under Negotiable Instrument Act, in my respectful submission, because he is an accused in this case, he has to face the trial. He can raise his defense at the time of cross-examination. He can also raise his defense in the 313 statement, and he can give defense witnesses. And under preponderance of probability, he can prove his case. So in my respectful submission, even assuming that the two cases are tried together, they have a different cause of action, your lordship.
No.
In my respectful submission. It will be tried together.
313 is the last stage.
Yes, they can discriminate. I am not against that, your lordship.
What will be at a disadvantageous position? I won't decide this. They will raise the issue of that.
Yes, your lordship, in the trial court they can raise, yes, definitely, your lordship.
Club these cases together.
Yes, your lordship, that can be done, but this particular
And
prayer that
London
they are
court
making in
would
a
try
second
both
revision,
cases
lordship, they
together
cannot
in
be
accordance
allowed.
with law. In
Because
accordance with law. I am not praying for a favorable order. I only saying both the cases may be clubbed together and the learned court will dispose of both the cases in accordance with law. In that view, case may be disposed of.
In my respectful submission, your lordship, whether this honorable court will mold the relief in
That
a
means he has
4:2
some fear. He
in-
has some fear.
whether the
He has, why he is objecting it to try both the cases together?
whether this honorable
This is
court,
the law.
whether the honorable court will mold the relief, your lordship, in a 482 petition where they have made a specific prayer that they may be allowed to examine their check in through the forensic laboratory, your lordship.
That's it. I'll have to hear and then discuss.
Yes, your lordship, I'm ready for the hearing. And that is the only point that to be decided, your lordship, whether that particular check needs to be sent to the forensic laboratory. The Honorable Supreme Court is very clear, your lordship. Once he admits the fact that the check has been signed by him, the question of sending that particular.
Let the records come. Otherwise, there was a good, if agreed by both of you, I could have disposed it of. There was a good way of disposing it of, but if not agreed, then we'll hear it. We'll call for the scan copies of the record.
Yes, your lordship.
Both the.
Learned Counsel Mr. M.U. Mahmood is present and has prayed to call for the scanned copies of the trial court records. Learned Counsel Mr. T. Devi is present for respondent number 1 and has submitted that the records are not required. However, for the interest of justice, call for the scanned copies of the trial court records of CR case number, how much?
23/24 and complaint case number 49/2024. From the
List-
court,
List immediately after the preservation. Or before.
No, yes, your lordship, after
List
Bihu.
immediately after.
After
the-
Bihu.
record may not come. Short
After
date
we
record
also-
may not come.
No, your scan copies will come. Scan copies will come, but we do, I think last 2 weeks will be for motion only. There will be a notification soon.
After the winter vacation, your lordship, may I pray for a date, your lordship, may kindly.
Pending
Okay,
for
okay,
the,
okay,
pending
that
for
is-
the Linus CJM, Kokrajhar.
Yes, that's.
Yes,
we know.
deeply obliged.
Obliged.
CD receipt, lordship.
CD receipt?
it is.
May please your lordship, a regular bail petition, my lord, FIR is at page number 11. And today is 49 days, the petitioner is behind bar, my lord. 11 is the FIR, my lord, page number 11. May I read, my lord?
Yes.
With due respect, I beg to state that since last 8/2/2025, my brother, namely Sri Alaluddin, along with Sri Faizuddin, both are missing. In this regard, on 10/2/2025, already I have submitted a written FIR before the Boraigram WP. On last 12/2/2025, at about 1 p.m., the accused number 5 came to our house and informed us that some miscreants detained my brothers, namely Sri Alaluddin, along with Faizuddin at Sonamura, Tripura, and my brothers could be recovered if we go with him to the spot. On good faith, I went there along with him, but could not find my brothers. Subsequently, the accused number 5 showed us a video footage about the detention of my brothers and frequent communication with the doubtful miscreants. I could assume that the accused person in connivance with the accused number 1, 2, 3, and 4 by making a conspiracy kidnap my brothers. It may be mentioned here that the accused prisoner are involving with the drug supply.
Okay, I have the CD, I'll just read the CD.
I am not the FIR named accused.
Lordship, just read
Kindly
the
peruse
CD.
the statement of victim, lordship. They have lordship identified lordship. And lordship, one bail objection is also there, lordship. The arrested accused person, this Kamrul Haq, alias Taju, is directly involved in Pathargandhi PS case number 47 of 25, who along with all the FIR named accused person, along with all the previously arrested accused person, organized a group and kidnapped the victim, namely Alauddin and Foizuddin, for ransom. Sufficient evidence has been found against Kamrul Haq Taju, as during the time of statement recording under section 183 BNSS, both the victim confirmed his involvement in the case, lordship.
But all the accused person has already got bail, my lord. Even two accused FIR
Just a
named
moment,
accused
just a
are got in
moment.
motion
Just a-
stage, my lord.
Just a moment, please allow me to read the CD.
My lord.
Inserting pins in their fingers, pouring hot oil, torturing them.
But, these are the CD. I'm not going to argue on the CD, my lord. But my lord, what happened, my lord? All the accused persons who were arrested, all are granted bail.
Lordship,
And
others
14,
others granted bail on the basis of an assumption, but here
No,
this
my lord.
petitioner Lordship,
It is not a
direct
matter-
involvement is here,
it is
Lordship.
not a
183
assumption.
statement is before you,
It's
Lordship.
the orders, my lord. And now I am behind by my lord, and so far let them fire. Investigation has been progressed. Let them
This is
file a
worse
suspect.
than murder, the way they have been treated.
Next is from 17, my lord, page number 17, my lord. Your lordship has also granted a bail, my lord, because of the progress of the investigation, my lord, which is at page number 17, my lord.
Page 17.
Yes, my lord. This is the FIR named accused number 1. Yes, at page number 18, my lord, paragraph 10. Although there is incriminal materials, my lord, because of the detention period and the progress of the investigation, your lordship has granted bail, my lord. He is the FIR named accused. And other two FIR named accused also granted anticipatory bail in motion stage, my lord. So investigation has been progressed, my lord.
Lordship,
Defend my case.
investigation of the case is yet not completed, Lordship. If the accused person released on bail, then other co-accused person will Lordship, will be very difficult to arrest, Lordship.
Already a FIR named accused has been granted bail, my lord. And other person were also arrested, they also granted bail, my lord. And keeping me behind the house and further investigations, my lord, when
How long you are behind bars?
49 days, my lord. I was arrested, I have annexed the, my lord, at 26 is the forwarding letter, my lord, 17/10/2025.
What is the highest punishment in this offense?
Up to 10, my lord. Up to 10, my lord.
What you see that offense kidnapping and then torturing, inserting pins and hot oil. That torture, what, it will come under which section? Pouring hot oil,
61%,
inserting pins on their fingers. It will come under which section? This will not come under kidnapping for ransom. It will be more than that. No.
So I am, my lord, this is just progress of the investigation as well as detention and other has been already released, my lord. On that count, my lord, I am paying for, my lord. Otherwise, I am in judicial custody, not in police remand also, therefore, my lord. And your lordship's order has already been stated that there are progress in the investigation, my lord. So keeping in view all this, my lord, any terms and condition your lordship may impose, my lord. Okay.
Okay. Okay. Under conditions.
Lordship, my objection is real.
Yes. There's no offense also, no, describing this torture, real and continuous torture,
Okay.
causing hurt.
47, it is not raised, it is registered only under section 61.
612 and 140.
140.
Causing hurt only, anything else? Coming to your
Kidnapping
mind?
with the intent to murder, my lord, that is the 141, my lord. That is the
One would have died. Somehow he has survived.
Yes.
Alauddin, he would have died. Third learned counsel, Mr.
M.A.I. Hussain.
M.A. Ali.
M.A.I. Hussain.
M.A.I. Hussain for the petitioner. নাম তো সাইডে লিখে দিবা filed his application under section 483 of the BNWS 2023 with prayer for bail as he is behind bars since so and so under so and so sections. What is the date behind bars?
From 17/10/2025.
17/10/2023.
25.
140, subsection 1, kidnapping or abducting in order to murder, imprisonment for life, Lordship. Imprisonment for life, not at this
No,
stage.
no, not to murder. With attempt to murder.
Yes, Lordship, 140, subsection 1 is, Lordship, it is here, Lordship.
It is there.
Yes, Lordship. It is registered, Lordship. This case is registered under section 1401 BNS. 1401 BNS, kidnapping or abducting in order to murder, imprisonment for life.
Or in rigorous imprisonment for up to 10 years. Along with fine.
Why did you say up to 10 years?
My lord, PNS, my lord, I am confused, that's why, my lord. Because or rigorous imprisonment up to 10 years.
90 days offense.
Change my lord, BNS 90 days. 90 days. Then my lord, any tough condition, my lord, may impose, my lord, because
Not at this stage, Lordship.
They do not deserve bail. I'm granting bail, they do not deserve that. Because you see, earlier I had granted bail at same period of imprisonment.
But Lordship,
49/2025, same 40 days, I think.
47 days, my lord. On that,
47 days.
days.
but this petition is directly implicated by the victim, Lordship.
Yes, yes, he is directly implicated.
Yeah.
And this Samim Ahmed, he was not implicated. Let's see.
By just, with the order, my lord, just intervention.
He was also implicated directly.
My lord.
How can someone torture a human being in that manner? I don't know. Not 1, 2. For ransom. For money, that too not much. Earlier they asked for 1 crore and then they came down to 10 lakhs. For 10 lakhs, they, God knows, how can someone torture like that? For the petitioner so who has filed his application under as is behind bars, heard Ms. Endas Learned additional PP Assam who has raised serious objections stating that the petitioners are booked under a serious offense and the other accused are yet to be apprehended, full stop. It is submitted that if the petitioners are released on bail, it will, the petitioners may affect, the petitioners may influence the witnesses and the investigation may be affected. It is submitted that they are incriminating materials of gruesome conduct on the part of the petitioners and bail may not be granted to the petitioners considering the aggressive nature. Full stop. It is submitted on behalf of the petitioners that the petitioners may be granted bail on the ground of parity. Full stop. The petitioners are also willing to abide by any stringent bail conditions if imposed upon them. Full stop. I have scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioners. Full stop. The allegation against the petitioners is that they have kidnapped the victims Alauddin and Foiz Ali, Foij, Foiz Uddin, and they tortured them for ransom of rupees 10 lakhs, inhumanly tortured them. Full stop. I have considered the progress of investigation and the length of detention. Full stop. It appears that further custodial detention may not be required for the progress of investigation. Full stop. I have considered the submission that the petitioners are local residents and are not flight risks. In view of the foregoing discussions, petition is allowed. The petitioners are enlarged on bail of rupees 50,000 each with a suitable surety of like amount to the satisfaction of the
Srijam
Huh?
Sribhumi.
Srijam
Sribhumi.
Sribhumi, under the condition that the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 2, the petitioner shall not exercise threats to the witnesses or try to tamper with the evidence. Number 3, the petitioner shall refrain from such activities with which they are alleged. Number 4, the petitioner shall not leave the jurisdiction of the court without prior permission. Full stop. On breach of any of the bail conditions, bail order, the court is at liberty to cancel the bail granted to the petitioner and back the CD.
There is only one petition, I don't, Dr. has declared.
Oh, petitioners here. One petitioner, the petitioner will be one petitioner.
Highly applicable.
Or each person, no, one petitioner.
Item
One
21.
petitioner. For the city.
21 charges submitted. Lord.
Learned Counsel Mr. S. Brofer is present for the petitioner. Learned Edison TP Ms. N. Das has submitted that charge sheet has been laid against the petitioner. The petitioner is directed to approach.
Section.
Section there.
So I'll give you a time.
But till
Yes, summons is not issued, yes.
till his appearance before trial court,
Uh,
if it is a sessions tribal matter. If it is sessions tribal offense.
Sections are not mentioned. I have only received the charge sheet number and date.
Actually, court will issue summons, but yeah, you want to continue with the.
Perhaps,
So I can dismiss it.
my lord.
I can dismiss it. You'll appear, I won't pass any order, I won't give you any condition. Because once you see that charge sheet is submitted, court issues a summon and then you appear. But if I give you a direction, you have to appear. So
Then,
how many against how many accused charge
On
sheet have
one.
been submitted? Let's
Lordship,
dismiss it, charge sheet has
no,
been
then I will not,
submitted.
I will be without any protection, man. Because
Then
I am
you
not,
appear, then without summons, 20 days,
my lord,
by then copies and everything will be ready.
my lord.
If there are other accused. Anticipatory bail, no?
My lord.
yes, Lord.
That there is a proceeding in the Supreme Court not to prefer anticipatory bail as far as possible, not before the High Court. High Court to discourage.
No, this was rejected there, man. We came after rejection.
Okay. Okay, then you appear after
My
50
lord.
days. Only one accused it appears.
One.
It appears so. FI. Charge sheet.
Lordship, CS number 29/2025. Dated 29/01/25.
Two accused.
I am for only one.
The other one is a woman.
Yes.
So she'll appear, I think.
Perhaps it may not have been charged against her, my lord. Perhaps only one person has been charged. I do not know, my lord.
One is shown as arrested. The woman has been arrested. I hereby forward the following person, Aklima Begum. She has been arrested.
My lord,
All right then, 20 days.
my lord.
Heard Mr. S. Das, learned counsel for the petitioner. Also heard Ms. F. Das, learned Excel PP, Assam, who has submitted their charges has been laid against the petitioner being CS number
29/2025, dated 29/01/25.
The petitioner is directed to appear before the jurisdictional court stroke Alaka magistrate within 20 days and apply for bail which may be considered by the court in accordance with law. Till then, no coercive action to be taken.
My lord, I'll hear this.
Item number 24 for orders.
Your Honor, I will make appeal for adjournment as my contesting advocate Dilip Dey is unable to come because due to death of his mother on 1st December.
This was for bail, criminal, oh, leave petition, okay.
So matter may be fixed after
Okay, after vacation, no? Learned counsel, Mr.
Dilip Dey.
Dilip Dey. You are Dilip Dey.
No, myself Arun Kumar Saxena.
Mr. A. Arun
AK
Kumar.
Saxena.
AK Saxena is present on behalf of learned counsel, Mr. Dilip Dey, and has submitted that learned counsel representing the appellant is out of station.
Out of station due to death of his mother.
Your name?
Hemanto Gogoi, H Gogoi.
Learned counsel, Mr. H. Gogoi is present for respondent.
Respondent number 2.
Respondent number 2 and learned additional PP Ms. D. A. N. Das is present for respondent number 1. List the matter after after puja vacation. Or after winter vacation. Immediately after winter vacation.
Publish.
Item 25.
Criminal appeal against conviction. Today is fixed for my IA for bail. The background of the prosecution case.
Here special PP forest wildlife lordship will appear.
Okay, special PP, this is forest case.
Forest case.
Yes, under forest act. So we will wait for some time, let him come. Somebody has to call him, I think. We'll wait for some time. let
After
him
some
come.
time.
Item 26.
Please, your lordship. Lordship, herein he was convicted under the regular criminal law, lordship. Thereafter, I raised the plea of juvenility before this honorable court. This honorable court directed an inquiry, and I have seen the report, lordship, he has been found to be a juvenile.
Yes. Report is it.
So I'm praying that the sentence and judgment be quashed and he may be remanded to the Juvenile Justice Board, lordship, as per section.
He's on bail, no?
No, lordship. He is in jail now.
He's in jail, oh.
Matter may be remanded back.
Hmm.
To try fresh.
Have you prayed for bail?
Yes, lordship. I is there.
How many days he is behind bars?
Now almost 11 months, lordship.
Do you have any similar case granted where bail has
Yes,
been
yes, yes.
Or we can take up the matter and set aside?
Yes, no.
Bail is not required only?
No, sir.
Yes. In other cases, it has been set aside and remanded to the
Do you have
jail.
any similar order?
Yes.
Where is the report? Have you submitted the report?
It's there, lordship. in
It
the
is
record.
there in the record, lordship. Flag
in
A,
appeal
lordship.
or IA?
In the appeal, lordship. Flag A, lordship.
Flag-
Main file, flag
Main
A.
file, okay.
Jamal is a division bench order, lordship.
Okay. Paragraph?
Lordship may look at paragraph 16 and 17. In Jamal. And the other is a single bench order, Lordship, Arunachal bench. Paragraph 14.
Okay.
Judgments were set aside and they were remanded to the JJT for appropriate orders. And section 9(3) also provides so of the JJT Act.
JJB নতুনখন লাগিব হা? Section 9(3).
3, Lord.
But Mr. Yuni,
Yes, they.
as the learned counsel, judgment form to লিখি দিব পাৰি দেই। Judgment and order order is বেছি নালাগে। Learned counsel for the appellant. এতিয়া নামটো লিখিব নোৱাৰি। Appellant X লিখি দিয়া। Appellant X and comma Miss Endas, learned additional PP Assam and learned counsel Mr. D. Gogoi for the respondent number 2. A report has been called from the, a report was called, High Order dated 5/9/2025, after an inquiry from the special judge POSCO Tinsukia. A report has been called nalage. It is a report. By order dated 5/9/2025, the special judge POSCO Tinsukia was directed to conduct an inquiry to the aspect of juvenility of the appellant by taking recourse to the requirements under section 94 of the Juvenile Justice within bracket Care and Protection of Children bracket close Act, 2015 full stop. The report has been received along with the proceedings of the inquiry. The proceedings were conducted to the satisfaction of this court. The entire proceedings is marked as P लिखी दिया, P and will form a part of this record. Okay? P. With inverted commas. After scrutinizing the original admission register for the year 2011 along with other documents, and after examining the head teacher of number 1 Selenguri LP School, Kakopothar, it was observed by the court that it was observed by the special judge POSCO Tinsukia that 25. On a precise calculation, the age of the juvenile X was found to be 14 years, 2 months and 21 days at the time of the incident. on 27/8/2020 as the date of birth of the juvenile X was 6/6/2006. This juvenile was tried as an adult and he was convicted by the impugned judgment and order dated
17/3/25.
17/3/2024,
25.
2025 in connection with POSCO case number 38 of 2020 under section
He was convicted under section 10, Lordship.
10 of the POSCO Act and sentenced to undergo. He was tried as an adult.
How can I also, but even for the sake of proceedings, well, I have to be there. So today without,
I'll give
I understand the anxiety.
Short date.
Short date, my lord. Next week, 17, 18.
Item number kiman asle?
25.
Learned Counsel, Mr.
B. Bora Lordship.
B. Bora is present. Learned Additional PP, Ms. Endas has submitted that
Lordship,
the
can it be on 7th if possible?
forest has to be made a party in this case. Have you made the forest a party?
No, they have to impede us.
I impeded state of Assam. I'll copy state of Assam,
Forest has
incorporate
to
it.
be made a party in this case. Full stop. The Learned Standing Council Forest. Forest will be enough, no? Mr. D. Gogoi has submitted that his name, he has not been included as a party and his name is not shown in the cause list and he has not received a copy of the application. Copy of the application. Full stop. Extra copies to be furnished to the Learned Standing Council Forest. List this matter on. Meanwhile, you file a.
The state of Assam is a Zenas, so he will come under it.
No, that's a different issue. No, that's a different. I'll clarify him, madam. We don't act as an FIR, we go through complaint cases, so
If
forest is a party, madam. 18 is.
18 December.
Lordship
You-
can
you-
consider
you
18.
Make party.
I'll file one.
No, that is, no, that can be, that
May
is
not
not,
be recorded, may not be
that not recorded.
His name only be reflected in the forest.
SC Forest will be doing, SC Forest and he'll do the needful, he'll serve the copy.
Read in the cause list.
Yes, fine.
I have not recorded this in the list in the.
Implicate korbo lagbo ni?
In fact, I have not included. it
Implement,
on-
we are also insisting, madam.
Obliged, Lordship.
Obviously, madam.
আৰু তিনটা আছে যদি দুটা any short submission I can take up. Submission has to be short.
Item number 32, Milo.
I am 27 and 28, Lordship. I am in 27 and 28.
27, 28, yes.
We have taken the step, Lordship, maybe
This one said it.
the service has waited, Lordship.
এইটো minimum দিব লাগিব। Send back, এইটো record, trial court record to send back কৰিব লাগিব, trial court record নেকি? Send back কৰিব লাগিব নে forward কৰি দিব লাগিব? Forward কৰি দিব লাগিব। এই চাই ল'ম। আগৰ judgment কেইটাৰ লগত চাই ল'ম। What to do with the records? Ponder over it. I'm stuck. Think over it, what to do with the records. Trial court record লাগিব নহয় এটা। Direct পঠিয়াই দিলে ডাঙৰ কথা হ'ব। Trial court এটা record লাগিবতো।
We have taken the step. Perhaps the service report is awaited.
Item number 27.
Oh, yes, yes,
27.
yes.
Both are
The
similar.
service report and respondent number 2 is awaited. List this matter immediately after the vacation.
Lordship, we need to take fresh step or
Petitioner may take fresh steps.
Lot.
It's up to you. Petitioner may take fresh steps. Are you too?
27, 28 similar matter.
27, 28 also.
Also.
Silos and Silos, he has. So
In 28 Lordship, let me copy. In 28 Lordship, he is the son of item number 27's petitioner.
okay.
One is son, one is father, Lordship. Other facts,
Service report on the respondent number 2 is awaited. Okay. Immediately after vacation.
Lordship.
It will 28, 29 নহয় ন?
No.
29 is adjourned.
Huh?
29 adjourned.
Okay.
Item number 32, Milo.
Yes, 32 has been mentioned.
No.
Yes,
Oh, okay,
I am the petitioner, my lord. What happened in this case, my lord? The respondent filed a enhancement petition, my lord. Initially 7,000, my lord, and jumping the 24,000 allowed as a maintenance, which is against the law, my lord.
Hmm.
That is my case, my lord. And already I
He's
have,
pending at which stage?
my lord,
Hearing?
hearing.
You place your hearing today?
Yes, ma'am.
Then will come in afternoon.
Yes, obvious.
30 to 33, no?
Yes, 30 to 30.
May I please, Lord?
Hmm.
So here I have filed a condonation of delay petition, my lord. There is delay of 38 days, my lord. Notice may go at this stage, my lord.
Petitioner, applicant to take steps to issue notice to the respondent.
Yes. Oblige.
Release the matter after vacation?
Yes, ma'am.
Release the matter release the matter for, did you get it? Release the matter immediately after the winter vacation.
My lord. Oblige.
31 9, no? 31 or 33 9? 33 9. Okay, we'll hear you in the afternoon. Then petition.
Civil petition. And even for the respondent to 5 respondent.
The records are not here. Will it be sufficient
He
to
said
hear the
yes,
case
yes,
without the
yes.
records? Yes,
Yes.
Actually, we have challenged one order of cognizance.
order, okay.
Yes, sir. Well, what happened here, this respondent, my lord, the was a estranged wife of the petitioner, my lord.
Mm.
She was the wife, she was my wife.
Mm.
Now we had been divorced. So marriage was solemnized in 2016,
Mm.
10/3/2016 at Dibrugarh.
Mm.
Then, my lord, due to differences, my lord, she voluntarily withdrawn herself
Mm.
from the matrimonial home, my lord,
Okay.
on 27/7/2017. After going out of the matrimonial home, my lord,
Mm.
she had filed multiple cases against me.
Mm.
One of them is one FIR, my lord,
Mm.
that is at page 1517. And I contested I faced the trial. Eventually, I was acquitted. Then your lordship, there is a DB case also filed by her in 2018, and that DB case also closed down